Hello, everyone, and welcome to this Federalist Society virtual event. My name is Sarah Clark, and I'm Assistant Director of Practice Groups with the Federalist Society. Today, we're excited to host this litigation update program on Petersen Energia Inversora, S.A.U. versus Argentine Republic. We're very pleased to welcome our speaker today. Mike Fregoso is a partner of Torridon Law. He recently served as chief counsel to Senate Republican leader Mitch McConnell. Our moderator today is Chris Murray, who is a partner at First and 14. If you'd like to learn more about today's moderator or speakers, their full bios can be viewed on our website, vetsoc.org. Throughout the program, we'll turn to the audience for questions. If you have a question, please enter it into the Q&A function at the bottom of your Zoom window, and we'll do our best to answer as many as we can. Finally, I will note that, as always, all expressions of opinion today are those of our guest speakers, not the Federalist Society. With that, Mr. Murray, thank you so much for joining us today, and I'll hand things over to you.
Thank you so much, Sarah, and thank you to everyone who's joined us today. And Michael, thank you to you for being willing to give an update on what is, a case when it comes to suing a foreign country is beginning to approach Jarndyce versus Jarndyce, levels of length. And I think probably a good place to start, because we've probably got folks in the audience who are familiar with the case and some who may not be familiar at all. I know if you practice long enough, you end up in some complicated litigation. And folks who have been in a case for a long time, especially when it's as multifaceted as Petersen is, it can almost get hard to summarize a case for new folks. But Michael, I think you actually came into the case this past summer, if I'm not mistaken. So you just had to do this and sort of learn the case. So could you give maybe a high-level summary of where the case is and what it's about and how it came about?
Sure. Thanks for moderating, Chris. It's great to see you. And yeah, as you say, it's a case that's been going on for quite some time. It's been going on for over a decade. And these cases that go on for this long wind up getting pretty complicated. And this one is no exception. So I guess big picture, it's Petersen Energia Inversora versus Argentine Republic. And it's in litigation in Manhattan, both in front of the Southern District of New York before Judge Loretta Preska, and then also in the Second Circuit Court of Appeals. The most recent sort of really big ticket item that happened on it is in October, late October. The Second Circuit heard arguments on the merits of the appeal from SDNY, but it's a complicated case with a lot of other moving parts, which we can get into. I guess it might be helpful if I just sort of explain the background of the case and where it came from.
Yeah, please do.
So in 1993, Argentina privatized its national oil company, Yacimientos Petrolíferos Fiscales, or YPF. Everyone just calls it YPF because the actual name is a bit of a mouthful. This was during the Carlos Menem presidency. And so he was, a president of Argentina who tended to favor liberalizing reforms and privatization. And so this was part of that privatization agenda. But in order to privatize the company and do it effectively and raise the amount of money that they wanted to, they sold stock in it that was listed on the New York Stock Exchange in an IPO. In so doing, they wound up raising over $1 billion in U.S. capital markets for the sale of YPF to private investors. The trouble is that sophisticated American investors aren't necessarily in the business of just putting their money in the hands of Argentina. It's a country with a long history of economic populism, socialism, Peronism, and they have a tendency to nationalize industry from time to time. So in order to have a successful IPO and to get American investors to buy into this thing, Argentina needed to provide some kind of protection for these investors. They did it in the form of bylaws for YPF, so company bylaws that promised, and the way they did it is they promised a tender offer to minority shareholders from YPF and the government in the event that it were nationalized. So the bylaws provided that provision, and then they also spelled out the precise calculation of such a tender offer. So it could forestall, later gimmicks involving, say, exchange rates or inflation and things like that. The IPO's prospectus for the YPF stocks, which was registered with the SEC, described this tender offer requirement. So, people investing in this IPO, if they're doing their due diligence and reading the prospectus, they learn about that there's this tender offer requirement there to protect them from nationalization. And so it was, again, they're both in the company bylaws and in the prospectus. In fact, the prospectus said, under the company's bylaws, in order to require a majority of the company's capital stock or a majority of the Class D shares, the Argentine government first would be required to make a cash tender offer to all holders of Class D shares on terms and conditions specified in the bylaws. So that was at the time of the IPO. YPF shares wound up being listed and traded in Buenos Aires. They're also traded in New York as American Depository Receipts, or ADRs, and those were issued by the Bank of New York Mellon. And things basically went fine under this arrangement until about 2012. In fact, at one point, the plaintiff here, Petersen, purchased a stake in YPF that put it over the threshold in the bylaws requiring a tender offer. So in order for Petersen to get that stake, they wound up having to pay a 30% premium on the stock price in their payments to minority shareholders in order to comply with the tender offer provision. So that's the extent to which this provision was deemed to be, binding on parties who owned this stock in the time between the IPO and then the nationalization in 2012.
Sure.
I gather they felt that there was a new level of profitability in Argentine oil production, and the Peronist Cristina Kirchner government then, seized control of YPF and did so without making the required tender offer. They have an expropriation law. They followed it. The Argentine officials went to YPF's headquarters and literally just seized control of the facility. The Argentine finance minister at the time, Axel Kicillof, said that only fools would agree to comply with the terms of the contract because it was a bear trap and that the Argentine government wasn't, quote, stupid. And therefore, no tender offer wound up being made. If you sort of follow contemporary Argentine politics, you might recognize Kicillof's name. He's in the news sometimes. He's probably the most prominent remaining Peronist in Malay's Argentina. He currently serves as governor of Buenos Aires. I think there's probably little love lost between those two. So, result, YPF stocks collapse. U.S. shareholders who were backed by pension funds and commercial banks, they lost billions. Some of them went into bankruptcy. Shareholders wind up filing suit in the Southern District of New York, as YPF was an NYSE listed entity. And the litigation has, as you said at the outset, kind of persisted since.
All right. And I guess maybe the biggest question, well, there's a lot of big questions that this litigation brings up. But maybe one of the biggest questions, and it seems like it was the question that the Second Circuit was focused on at arguments back in October, is, well, why file this in New York? Why can this be brought in New York? Why can it be brought in the United States?
Yeah, so it was filed in New York for a number of reasons. One is that the YPF shares are NYSE listed, was listed on the NYSE. Another is that Petersen is one of the plaintiffs. The other one is Eaton Park, which is a New York hedge fund. So they have natural venue there. This wound up being litigated pretty extensively in the district court. And the judge had a variety of reasons for wanting to keep it in New York, not least of which is, the fact that the IPO was issued in New York. You have American investors, you have interest in these sort of American investments being honored, but you also wind up having some other kind of unique to Latin America issues. So the first time that the Argentines tried to move it to Argentina, It turned out that the Argentine government was criminally investigating Petersen's lawyers at King and Spalding. Judge Preska recognized the absurdity of sending the case to Argentina for one of the parties to potentially be arrested on pretextual grounds as soon as they got there. And then again, beyond that, like Eaton Park's a New York company. There's a public interest in New York adjudicating claims that stem from a purposeful availment of its investors and market. And so for those reasons, Preska decided to keep it in New York. That wound up, it's an interesting issue in the Second Circuit argument, because that's the one that sort of got the most news, because Judge Chin sort of asked, well, why isn't this in Argentina? So a little surprising, because I believe he was on the previous Second Circuit appeal where they said that the Argentines didn't have sovereign immunity in this case. But it was an interesting question, because at the argument, Argentina seemed to move away from its forum nonconvenience argument pretty quickly. The fact is that it's a very hard case to make in the Second Circuit. The standard for setting aside a decision on venue for forum nonconvenience is it's very high. The Second Circuit would need to conclude that Judge Preska, who's maybe one of the most widely respected judges in Manhattan, had abused her discretion in deciding that the case belonged in New York. They probably have to write around a fair amount of case law to do so. So even if they decided, let's look into that, suspect it's one of those situations where the clerks start looking at it, and we don't necessarily want to be doing. We have to distinguish how many cases, and so I think that makes it tough. Also, if you sit down and think about it, like the idea that Peronist courts would actually do a better job of interpreting Argentine law than the Southern District of New York, which was one of, again, the most sophisticated courts probably in the world, is kind of laughable. So Argentina really didn't press this issue as hard as one might have expected from the briefs, and as I gather, a couple of the judges seem to expect from the briefs. And instead, they focused on other questions. We can sort of get into sort of what wound up happening at that argument before we go back to all the other collateral issues that are being discussed out there.
Yeah, I mean, so I guess to me, right, and probably to several who were on the live stream, right, it was surprising that line of questioning even came up at the oral argument, about forum nonconvenience. I mean, I guess not if you just based it all on the briefs. And frankly, Judge Chin, right? I mean, he probably switched law clerks between the last arguments, right? And if I were writing a bench memo, I guess based on some of the briefing, maybe that question's in there. But what do you see as the real cleave points that came out of the argument on the merits?
I think what it wound up coming down to is an argument on Argentina's side that at the end of the day, the Argentine expropriation law is what governs here, and that essentially this winds up being a complex choice of law issue where which law governs Argentine law or New York law. And once you have Argentine law, how do you properly interpret Argentine law? And so that, I think it might be a bit of a subtle difference, but the argument was less so that the case didn't belong in New York, but that New York judges should be careful in interpreting Argentine law in potentially novel ways, because it is a pretty extraordinary case. It's not, I don't think there's a ton of precedent in Argentina for something like it. So they tried to argue that, in particular, Argentina, they have a law of expropriation that's reasonably comprehensive, and Argentina argued that that is what governs the case here, the expropriation law, not the contractual terms. So if plaintiffs wanted to recover after the expropriation, there's a process in Argentina to compensate people for expropriations, as one might expect, and they should have gone through that and not American courts. And that expropriation law, Argentina claimed, displaces all other claims. The trouble with it is that the plaintiffs weren't objecting to the expropriation at all. It's not about the application. of Argentine expropriation law to YPF. It's about contractual terms that were put in place separate and apart from the expropriation for use in the event of an expropriation, right? So the litigation's about the effects of that expropriation on those who owned the New York Stock Exchange listed stocks and ADRs under the terms laid out in the bylaws and the IPO prospectus. And so this is what Judge Preska had recognized, the way she put it is that the expropriation law provides no action by third parties, or no action by third parties may impede the expropriation or its effects. That's what the expropriation law says. Judge Preska pointed out that this litigation does neither. The expropriation happened, Argentina owns YPF, and they also just happen to owe damages based on a separate contract from the expropriation. So if it were the case that Argentina's expropriation law actually precluded the anti-expropriation protections included in the bylaws and in the prospectus, the fact is that the IPO in 1993 would have been a spectacular failure. And this is the point that our attorney in court, Paul Clement, made, I thought, very effectively. The fact is that there had to have been a meeting of the minds on that critical protection, or the deal never would have gotten off the ground. And so I think in the court's eyes, you wind up having, on one hand, a relatively straightforward breach of contract claim, and on the other, a sort of a choice of law thicket that tries to strangle that claim through inviting it to either make or not make rather novel interpretations of Argentine public law. And so at the end of the day, the Second Circuit, it's a sophisticated commercial court. Judge Chin's a very sophisticated commercial judge. Judge Cabrera, same thing. I think they will be able to see the forest for the trees here rather than getting bogged down in the intricacies of the Argentine civil law. And I guess just one point, going back to my time on the Hill, Judge Robinson asked very probing and thoughtful questions throughout. She was presiding because Judges Chin and Cabranes are both senior. And having worked on her confirmation in the Senate, I was not surprised to see that. She wound up getting a lot of opposition from Republicans on judicial philosophy, but she was very clearly one of the more talented, if not most talented, Biden judges. So it was interesting to sort of see her in action on the other side from having worked on her confirmation. And again, I wasn't surprised that she had really done her homework.
That's a nice bon mot. I mean, and so speaking of speaking of some interesting or I guess maybe some roads off the side of this litigation. You may have noted that there are some potential opportunities for investment in South American energy that have been floated by the current administration. And I guess I'd invite you to sort of contrast the situation that's being litigated about now, this 1993 IPO, right, with considerations about American companies, maybe getting back into Venezuela. Is there anything for folks who are looking at that to be thinking about and looking at your case to either draw lessons from or contrasts?
Yeah, I guess I don't really have anything to say on point with Venezuela and what should be done there. But as you say, we're talking about this Argentina issue at an interesting time, given what the liberation of the Venezuelan people from Nicolas Maduro. Expropriation winds up being a word that we're hearing a lot. I think the way to think about it, though, is that at first glance, this and that might seem similar, so Petersen and Venezuela, but I think the situation in Venezuela is fundamentally different from what's happening here, and the way to look at this issue is fundamentally different from, I think, the complicated and important issues in Venezuela. Sort of as we were just talking about, no one here is really challenging the expropriation of YPF. It's all about contractual terms established for investors surrounding the expropriation. And so it's really not an expropriation question so much as a contract question in the context of expropriation. As again, it's those contractual obligations that made the investments possible there in the first place. Instead of compliance with the contracts, we get Axel Kicillof saying that the complying with the contracts would be stupid. So it's really not about expropriation, it's about investment. And that's why I think it also comes at a very interesting time for Argentina, right? President Milei just had a wonderful historic victory in his sort of midterm elections down there. He obviously has a great relationship with the president and with the Treasury Secretary, and um, he's a he's doing great things to help clean up their economy. But at the end of the day, what he's going to desperately need to keep his economic miracle going is foreign capital. And foreign capital, I think, just as much today as in 1993, is going to want assurances that its money will be safe from future populist exercises in socialism. Because Milei might be president today, but he can't be president forever. So I think the best way to assuage the concerns of capital today is to show that capital 30 years ago made the right bet when it bet on Argentina. And the best way to do that is for Argentina to live up today to its contractual obligations from 30 years ago. And I think that um, maybe a little counterintuitively, I think that would help Argentina as President Milei tries to get back on the international financial markets and tries to get investment to come back to his country.
Yeah, I mean, and so it would seem, and that leads right into my next question. And it seems like the biggest issue, and I do want to talk about some of the remedies issues that are out there in this case too, because they're, I'm sure, very interesting to folks who are watching as well. But it seems like the big picture in this case is about, look, if you get access to American capital in in a foreign country, and American capital wants to put strings or wants certain legal protections that can be enforceable in the United States in order to make that investment, right? Can American capital count on that or not?
Yeah, I think that's exactly right. And I think that goes to one of the first big issues that kind of wound up getting litigated in this case. As I said, like this wasn't everyone's first time at the Second Circuit on this very case. The previous time it had to do with the Foreign Sovereign Immunities Act, or FSIA, and it went to that sort of very question that you just asked. Argentina was saying that they're a sovereign. They were a sovereign engaging in sovereign acts when they expropriated this thing, and they therefore should be immune from suit under the FSIA, and that's obviously jurisdictional, so that goes first. And they wound up arguing about it in the SDNY, and Judge Preska disagreed, sort of for the reasons that you just articulated. In the FSIA, there's an exemption for commercial activity, and the commercial activity exemption wound up being she held that it applied here, and it wasn't just sort of a sovereign act of a foreign sovereign. It was commercial activity in the United States. And so because of that, she said that the case could proceed. There's another sort of related doctrine called the active state doctrine, which prevents you from suing foreign governments for official acts. Technically, that one's not jurisdictional, it's a merits defense. And so she sort of put that one on hold as a common law defense that doesn't implicate jurisdiction. But since she said this was commercial activity, it wound up being a jurisdictional order, and they wound up taking up on interlocutory appeal to the Second Circuit. And the Second Circuit, well, no, this was within the commercial activity exemption. Then Argentina tried to seek cert on it back in 2019. The Trump administration, under Solicitor General Francisco, filed an amicus brief in opposition to cert at the time, and the court wound up denying it back in 2019. So since that first sort of skirmish on, as you say, what's this about? Is this about foreign governments doing foreign government things, or is this about the kind of contractual obligations that the government gets entangled in as it tries to avail itself of American investors? That question kind of wound up getting answered in, again, that first skirmish that ended 6 years ago now.
Well, speaking of skirmishes, and I don't, skirmish is probably unfair, but Another interesting aspect of this case is obviously the size of the damage award, right? That's drawn a lot of attention. But then also one of the remedies for the damages award that has been ordered by Judge Prescott, this handover remedy. Could you discuss that a little bit? As I understand it, it's a requirement for an order from Judge Prescott saying that, hey, look, to start satisfying some of this damages award, which there obviously hasn't been an appellate bond filed, right? Because you put an appellate bond in, well, then there's something to grab at a court. It's also would be a pretty big appellate bond. Judge Prescott said, look, you got to turn over some shares in order to start satisfying the award. Talk about that a little bit.
Sure, yeah. There's a couple things that wind up getting implicated in that. One is, as you say, it was a big award. It's $16 billion is what you wound up awarding Petersen against Argentina. And that has presented its own sort of set of litigation issues in the case. Those wound up being dealt with in the Second Circuit appeal that was heard in October. The Argentine arguments that damages should be owed in 2012 pesos converted to dollars at the contemporary exchange rate, or at the time of the judgment in 2023. And so that would use Argentine hyperinflation to wipe out 95% of the damages claim through the currency exchange rates. And Judge Prescott held no, the New York law requires damages to be calculated in dollars. There's an exemption where the contract denominates damages or denominates terms in a foreign currency. That was not the case here. So it's in the general rule and it's dollars. And so that is currently up at the Second Circuit. And I think the issues seem pretty straightforward. But as you said, like the remedy issue here, it's very unusual and goes to the complexity of this case. After Judge Prescott issued her judgment in 2023, and sort of recognizing the exceptional nature of this litigation, she proposed to stay the judgment on conditions that Argentina expedite its appeal and post some bond. Argentina did neither, which wound up making the $16 billion judgment subject to collection like any other. It's just an unstayed judgment. The fact is, we're talking about this appeal that we heard, that was heard in late October. That's an appeal from the 2023 judgment. So not only has the appeal not been expedited, the case has just been moving like molasses. And so while the case on the merits has been moving that slowly, there's this $16 billion judgment subject to collection out there. So that has just been since a subject of back and forth and litigation and discovery disputes between the parties. And this past July, Judge Prescott ordered Argentina to bring the New York Stock Exchange listed shares back to the United States to pay the judgment pursuant to the FSIA, because in her view, the shares were used for a commercial activity and were used for the wrongdoing that triggered the lawsuit. The argument against it has been that there's a common law comedy reason not to do this. And so, under common law, under the argument that these are Argentine property, you can't take it under common law comedy. Judge Prescott rejected that because her view was that she was taking the step because of Argentina's, quote, own actions in delaying and attempting to circumvent its obligations under the judgment, and that these were not property in Argentina. This is stuff that is trying to be attached, right? They're trying to just bring it to America so that property in America can be attached in America. And that is also currently before the Second Circuit. Argument on that, last I saw, is it's been proposed argument in April sometime. And so that's up there too. And that winds up being a question about the extent to which the FSIA applies in these circumstances, right? So the big picture issue is that historically sovereign immunity was based on these sort of common law doctrines of comity, and that wound up getting established through a sort of piecemeal interplay between the executive branch and the federal courts. And Congress decided to change that in 1977 when it passed the FSIA, which is, the Supreme Court's called it the comprehensive statutory framework for deciding when foreign sovereigns are and aren't immune to suit. And anyone who's worked in Congress for the last 2 decades knows the issue pretty well, because Congress is constantly having to rein in courts misapplying the FSIA, usually in the context of terrorism awards. And it's sort of probably not that surprising. Well, in those cases, when Congress winds up looking into those things, you wind up having two sides on the legislation. On one hand, you've got governments that don't want to pay, and on the other hand, you wind up getting victims of terrorism who want to be compensated and made whole. So it's perhaps not surprising that in the briefing in the Second Circuit, some victims of terrorism filed on Petersen's behalf because they don't want to get closed out through some sort of amorphous comedy view of whether they can get at the assets that they are owed.
All right. And, there's obviously the expectation with, the argument on the merits that was had back in October, that you probably get an order out of the Second Circuit sometime, maybe early spring, but with arguments set on the sort of, I guess it's not really a collateral issue, but a secondary issue for April. Is there any thought that you're going to have, instead of serial opinions, that you're going to have argument there and you're going to get one?
I don't know.
Yeah, dude, I don't mean to hit you with that one out of the blue. Just the timing strikes me.
Yeah, I think it would depend on what the Second Circuit's sort of rules on related cases are. I'm trying to think back when I was clerking. I think on the Seventh Circuit they might have been deemed related. But actually, I'm not entirely sure that would have been the case. I mean, here it's just been there has not necessarily been a decision to give it to one panel, let them stick with it. So, for example, with the turnover order, Argentina didn't seek a stay of the judgment, but they did definitely sought a stay of the turnover order. So they wound up getting an administrative stay pretty quickly after the July turnover order, and then they got a stay pending appeal later. And it was, I can think of at least 4 different judges who were involved in those two. None, I think maybe Robinson might have been the only one who was also then involved in the merits appeal. And then of the merits appeal, Cabranes and Chin, I believe, were previously involved in the FSIA appeal. So I don't know. It depends on what Second Circuit rules are, and I may be a little surprised if they wind up sort of giving it to the same panel. And to your point there, though, like that means that we're going to be waiting on an appeal from the merits panel sometime this year. Turnover is getting argued in April, so sometime later this year, there will be an appeal on the turnover order, and the two are not. It seems probably likelier than not they're not going to move in tandem, and so you'll wind up continuing with this sort of seriatim, important case issues in this case just sort of being decided on appeal. While again, all the while, because we have an unstayed judgment in the district court, that proceeds apace. I mean, just yesterday, Petersen filed a motion for sanctions against Argentina in terms of the discovery over the judgment. They've been fighting over off-channel communications, so WhatsApp communications and things like that. And it's been difficult to sort of get that, or at least the judge has found it difficult to get that from Argentina, and Petersen's found it that way too. So they filed a motion for contempt and sanctions, and they're urging the court to hold the Republic in contempt with coercive sanctions payable to the court, and then also precluding the argument that these state-owned enterprises, so YPF, Aerolínea Argentinas, and the 2 major Argentine banks, deem them to be alter egos of the government and make adverse inferences from these various communications. And so that will probably be another thing that has a hearing in the spring, sort of in the district court, while the circuit court's hearing another issue related to that same judgment, because again, that's sort of what winds up happening when you have unstayed judgments out there.
Well, I mean, and it's, I think I'll confess complete ignorance as to the interplay between uh, the rights of post-judgment discovery under Rule 69 and a foreign state actor. Is there a lot of law in that area, Mike, that you and your opposing parties are able to rely on in those sorts of fights?
Yeah, I think it winds up getting pretty complicated. At the end of the day, part of the issue is that Judge Preska has personal jurisdiction over Argentina.
Right.
And so since she has that personal jurisdiction, she has a lot of tools available to her, not only under the federal rules of civil procedure, but under New York law, um, to try to compel compliance with her discovery orders.
Yeah. I mean, that's, that's just it, right? It's that, once you're talking about a judgment and the judgment is in place, right? The court's in the position of having to assist the party in enforcing it. I mean, so I'm, you mentioned earlier in our chat, Mike, that the 2019 petition for certiorari that was denied on the foreign sovereign immunity issue. I guess given the number of issues in the case, maybe what I'd like you to do, is sort of just from the point of view of a practitioner and maybe less an advocate, um, you know, give maybe the top three sort of in terms of novelty, um, and then whether you think on any of those there's going to have to be a trip up to SCOTUS to get those resolved before this case can actually be finished.
Yeah, that's a really good question. There's a lot of novelty here generally. I think that we saw it last time with the FSIA question. I think it's probably safe to say that both of these Second Circuit appeals, regardless of how they go, you can probably assume that someone's going to want to seek cert on them, right? I think the case is just such a important case for everyone involved that I don't think anyone's going to want to leave anything on the field. That would be my guess there. And in terms of what is sort of cert worthy, I mean, I think if we were talking earlier about the comprehensive nature of the FSIA in the context of sovereign immunity, I think if the Second Circuit were to hold that somehow amorphous common law comedy terms still exist out there after the enactment of the FSIA and in contravention of Supreme Court opinions that have said that the FSIA is the comprehensive way of looking at litigation relationships with foreign sovereigns. I think that's something that it would really behoove the court to clean up. And it would behoove the court to clean it up here because I think it would be an incorrect ruling on the turnover order. But sort of going back to what I was saying earlier about the importance of this issue, it comes up every Congress in terms of the terrorism point of view, right? Where terror victims, they've got these judgments against foreign governments for the actions of state-sponsored terrorists, and they wind up having no way to collect on these judgments. It winds up being extraordinarily difficult because of courts will start importing some of these common law doctrines. And so I think it would be really important for the Supreme Court to sort of specify, like, no, this was in Congress's hands, and Congress decided what to do, and we should continue to listen to Congress here. They've been saying it in the past, and I think if this case, if the turnover order winds up getting struck down, I think this will be a good opportunity for them to sort of say, no, we have meant it in the past when we said that the FSIA is a comprehensive guide to how these litigation interactions will work. In terms of the merits, I mean, I think you wind up having two issues when the Supreme Court's looking at stuff, right? One is sort of the case itself, and the other is the law and
Yeah.
what to do in the law. I think the turnover order presents good arguments both ways. I think on the merits, um, the case itself, you've got a foreign government involved in it, right? You've got a lot of money on the line. It's the sort of thing that the Supreme Court might want to take a look at. And I think it's the sort of thing where, again, if that one goes, from my view, the wrong way, and it's deemed that, foreign thickets of civil law can extinguish uh, contracts that are in IPO prospectuses as you're trying to get American money. I think that also winds up becoming an important issue, not just for this case itself, but more broadly. Like, um, what does that mean for future investments? I think it would make it pretty tough to try to justify that in Argentina. And, again, Venezuelan investment is generally different, but if Venezuela becomes a, God willing, more stable, investable place, they might in the future be encountering issues like this when they're trying to get money, right? And so the ability to allow private investors to feel comfortable with government assurances overseas in their investments is, I think, not just important in this case, but important in cases across the board. So I think in both of those appeals, there's plenty for the court to look at. And I think in particular, if Argentina wins either of them, it's entirely appropriate for the court to look at them.
Yeah, and I guess I do have one follow-up, beyond also SCOTUS, just because you have so much experience on the Hill, Mike, right? You know, it's as you said, there's a lot of legislation that doesn't move on the Hill anymore, right? It's just the nature of the partisan divide in the country. But the the contours of foreign sovereign immunity, especially in civil matters implicating American capital, that's something that does attract attention up there, both I think with a Republican Congress and a Democratic Congress. Um, do you think, let's say again, and I'm obviously this is from your point of view, uh, that if the case were to go significantly afield or to interpret the contours of foreign sovereign immunity legislation, in a way that makes it a little bit more difficult to invest abroad. Do you think that's something that might attract attention in Congress again for an update?
Potentially, I haven't really thought about that too much. As you say, we've talked about it. It attracts a lot of interest in Congress, and it winds up attracting kind of diverse interest in Congress, right?
Right.
The battle lines are not really Republican Democrat on these questions. It really does tend to be victim government. There was a law that was passed in late Obama, JASTA, that Obama vetoed it, and we overrode his veto because it was a justice against state sponsors of terrorism. And there's uh, a number of our allies in the Middle East really did not like that bill, and the State Department did not like that bill, and so it got vetoed, and then it wound up getting again overridden and enacted. And they're always sort of trying to perfect it. As again, courts tend to resist what the statute tells them to do, and whenever there's a sort of rifle shot to try to protect it, it's not a Republican Democrat thing. Lots of Republicans and lots of Democrats want to fix it. It winds up being that against pressures to treat it as a diplomatic question rather than a legal question, which senators can wind up feeling those pressures as well. So that's how it's tended to work. And so in this context, I mean, you could potentially wind up seeing interest in protecting American investors in Congress. I think in the shorter term, though, insofar as there are members of Congress who are interested in Latin American investment, which I think there are probably plenty, right? We're making sort of big steps in the hemisphere to try to turn it into not just, the occasional beacon of freedom like the United States and Costa Rica or something, but lots of good, free rule of law countries in the hemisphere. I think any members of Congress who are interested in that should be paying attention to this case and paying attention to asking themselves, what can we do to help maintain the confidence of investors in Latin America to help our allies like Argentina, our hopefully soon, partners in places like Chile. They just had a really good election down there, or hopefully soon partners in Venezuela after they sort of come out from their decades of oppression. So I think you don't even, a short answer is you don't even necessarily need to wait for the stuff to conclude. I think if members of Congress really want to ensure that our private sector appropriately and profitably helps Latin America under the kinds of terms where we want our investment going, they should be paying attention now.
Right on. All right. Well, I've got before we finish up, we did have one, I thought, a very good and very basic practice question from one of our attendees, which is, hey, just was there, in the IPO, right, or the prospectus, was there a choice of law provision?
That is a good question. I don't think there necessarily was, because so there are bylaws in Argentina, right? So as YPF is an Argentine company with those bylaws, and then the IPO is referencing those Argentine bylaws. And so there isn't while there's a contract and a breach of contract, the contract itself wasn't specifying, I don't think, which law winds up getting implied, or which venue here's the case, right? Those kinds of contractual terms that you sometimes see, I don't believe were present here.
Yeah, and it's a good question from the person who asked it. I will say, just remember as a little historical lesson, in 1993, America ran the world and nothing bad could happen. So that's but very good question. And I'll say, before we go, Mike, is there? I guess we talked about the timing for a decision maybe from the Second Circuit. If folks are looking for developments in this case, when do you think that decision comes out? When do you think the decision on the turnover from the Second Circuit comes, assuming that obviously the merit side is affirmed, and when do you think do you think it's all sometime this year that both those decisions come out?
Yeah, I mean, as well as anyone, that it's guesswork and trying to figure out when a court of appeals is actually going to put out an opinion. I remember when I was clerking, if we were on a panel with Judge Easterbrook, it could come out the same day. Whereas ours could come out considerably later. So these are complicated cases, so I'm sure the judges are really taking their time to make sure that they, in their lights, get it right. That said, I think it seems if you have one argument in October of 2025 and another argument in sort of mid-spring 2026, it seems entirely reasonable that both would wind up getting decided within 2026. Where on the calendar that ends up being, it depends so much on which judge has it and whether the colleagues agree, whether there's a dissent and all of that. So I wouldn't venture a guess on specifics other than it seems entirely reasonable that both would come out this year.
Okay, right on. Well, any parting thoughts for our attendees, Mike, before we turn it back to Sarah?
No, thanks everyone for attending. I think it's an interesting case. It's only going to keep on going and getting more interesting. And thanks for your help moderating, Chris.
Oh no, it's totally my pleasure. Sarah, thank you very much for having us, and we'll turn it back to you.
Yeah, thank you so much. On the behalf of the Federalist Society, thank you both for speaking with us today. We're so grateful for your time and expertise on this important topic. Thank you to our audience for joining us. We really appreciate your participation. You can also stay up to date with other announcements and upcoming webinars on our website, fedsot.org. Thank you once more for tuning in, and we are adjourned.